I'm here with Professor Brian Kalt, law professor at MSU, constitutional scholar, focusing a lot on presidential power. And we are going to get to the bottom of some questions that I've had, that I know you've had, about impeachment. Professor, people talk about impeachment, they throw the word around. A lot of folks say Nixon was impeached, which of course he wasn't, but he was on his way perhaps to being impeached. And then some people believe that impeachment, if a president is impeached, that means he's gone. So I want to get some of the legal fine points out of the way, and so we can get into the meat, because when you talk about impeachment, these legal definitions matter. So I'll start with my plebeian understanding, and then you can correct me. So there is an impeachment inquiry going on against President Trump right now in the House. My understanding is that the House is sort of like the investigatory or prosecutorial arm, whereas the Senate is the jury or the judge part of the trial. Because a president, I guess, can't be charged with a crime, we'll ask you that, we have this impeachment process. And the president can be impeached for high crimes and misdemeanors. What does that mean? Do they have to be high crime? What about low crimes? Does this mean that the president can do little petty crimes? That it has to rise to this level of high. But let's start. So let's start with, I've asked you a lot of questions. What is impeachment versus conviction? Have we ever been here before? How many presidents have been impeached? How many have been convicted?
So the process, as you said, starts in the House, and an impeachment is an accusation. So the House, by a simple majority, can pass a resolution impeaching the president or any other executive branch or judicial branch officer. We've had a fair number of impeachments, but only 3 presidents have faced serious impeachment inquiries.
So the other ones were mostly what, federal judges or
all,
something?
All the rest are judges. There was one senator who was impeached, which established that in that case that you can't impeach a senator, and there was one secretary of war who was impeached. But the only people who have ever been convicted by the Senate are the judges. So we've had 3 presidents face impeachment. President Johnson, Andrew Johnson, in 1868. President Nixon was about to be impeached. The committee, the Judiciary Committee, had passed the resolution, sent it to the full House. He was going to lose in the House. He was going to lose in the Senate after the Senate trial. So he resigned. And President Clinton, who was impeached but not convicted. So impeachment is just the accusation. The House
is it akin to an indictment?
It's
perhaps in the
I think
court?
It's important to note that the impeachment process is intentionally separate from the criminal justice process, but it does have analogies. So it's like an indictment. It sets him up for trial in the Senate.
And then the Senate is the trial, the jury, so to speak, and the
Yes.
Senate votes.
And 2/3 are required.
It has to be 2/3 to convict. What if, speaking of course, in the abstract, what if the president, a president, is convicted? If Clinton had been convicted in the Senate, is the penalty set forth already, like in other crimes? Is there a given penalty, or who determines the penalty?
So the Constitution, in order to separate this from the criminal justice system, and in order to separate it from British practice, where impeachment was about, if you were in the House of Lords, they wouldn't take you to the grubby regular courts. You would have a jury of your peers, quite literally, in the House of Lords. That was anything that one of those folks did was subject to the impeachment process. But then the penalties were whatever the penalties for crimes were, including death. Here we said, no, this is just about safeguarding the integrity of the office. So all this is about, it's not about criminal penalties. It's about, if you get convicted, you're removed.
So the only thing at stake is you're holding the office.
Well, there's one other. So if you're convicted, you're removed, if you're still in office at the time. But there is one other possibility, and that's disqualification. After someone is convicted, the Senate, by a simple majority vote, can add the penalty of disqualification.
That you could not run for office again?
Not run for an office under the United States of honor, trust, or profit. And what that means is appointed office, not Congress. You can still run for Congress. Some people say that doesn't include the presidency. There's some disagreement on that. Most people think that you could probably still run for president.
So you mean to tell me that the founders were vague even on this subject? Even on whether you could run for office again? Now, why would there be ambiguity in something to me that should be clearly black and white.
Well, it's up to the Senate. First of all, they don't have to. They have to remove. If someone's convicted, they get removed. But it's up to them to decide whether to disqualify the person in the first place. And I don't think they thought they were being vague. I think they knew exactly what office of honor, trust, or profit meant. We just haven't had this happen enough, and so we're not familiar with it. But as a practical matter, they don't usually bother disqualifying anyone, because if someone has been impeached and convicted by 2/3 vote in the Senate, they weren't going to get confirmed for any office anyway.
But what you're saying, Professor, is that should President Trump be impeached in the House and convicted in the Senate by 2/3, you're saying it's quite possible he could still seek re-election.
Well, politically, he would be in a pretty tough spot, because if 20 Republican senators voted to convict, along with all the Democrats, that suggests that they're gauging it that the base that he's lost the base. So it would be hard for him to get the nomination.
But again, but legally, he could seek re-election.
I would expect them to vote to disqualify him, and then if he really wants to run, if he really wants to push this legal issue, and adopt the interpretation that some people have, that the president is not, that it only applies to appointed office, not elected office, that he's not disqualified, he could do that. But I would think that if we're in a situation where he, in that setting, could win, we've got bigger problems than
right. He probably wouldn't, but I'm just saying. I just want to get down to what is possible first. Now, you mentioned a vote on impeachment, and I want to get this crystal clear with the professor, because I've heard a lot of naysayers, a lot of folks on the right, talking about how Nancy Pelosi isn't doing it right, and Nancy Pelosi this and Nancy Pelosi that. Of course, I think Nancy Pelosi has been grace under fire and has done a phenomenal job. But we're here to talk about the law. So my question for all these constitutional yahoos who think they know something, my question is, does Nancy Pelosi, as Speaker of the House, is she doing it wrong? Should she have taken up a vote? Did she have the authority to stand up and announce the impeachment inquiry as Speaker of the House and begin in the various committees, begin the subpoenas and the questioning? Or should she have in fact taken a vote on the front end to start the process? Is Nancy Pelosi out of line?
Well, I don't think she's out of line. It is, there is precedent for proceeding based on a vote, a preliminary vote, to sort of kick things off, and there's also precedent for not. Impeachment usually will come through the committees, and the committees can do whatever they want. The question is, what does it mean to say that it's an official impeachment inquiry? What does that add? And the answer is really not much. The idea is, if it's an official impeachment inquiry, whether you had a vote or not, if it's an official inquiry, that the president doesn't have the same power to resist. That if the checks and balances, separation of powers, if the House is doing this, he needs to cooperate. But then the question is, well, what happens if he doesn't? What happens if he's not only not cooperating, but he's not cooperating with an impeachment inquiry? And the only remedy for that, really, is impeachment. They can add that as another article. And that was Article 3 of the Articles against Richard Nixon that they approved, was for stonewalling the impeachment inquiry.
Yes.
And so it doesn't really matter.
From a precedential basis, and I know you law professors, these law professors, I know you're big on, if I can stereotype, I know you guys are, because my daughter's now a lawyer, I know you guys are big on precedent. Not president, precedent. Okay, past cases. So what does the Nixon impeachment process, I thought a lot of these things were settled. Like when I hear Pompeo or other Trump people saying, we're just not going to cooperate with the House, it's like, what are you, this is not a dictatorship. Like, there's no not cooperate. When I hear the executive branch say, we're not going to cooperate, we're not going to give you this document, that to me is scary. To me, that's flaunting the checks and balance, the balance of power that the Founding Fathers put forth, and potentially setting up a quote-unquote constitutional crisis. Whether or not there's an impeachment inquiry, it seems to me Congress has the authority, and I thought the subpoena power, So I'm asking a couple questions there. One, what are the powers of Congress? Are they in fact a co-equal? I keep hearing co-equal branch of government. Are they in fact co-equal? And again, what did we learn from Watergate, from the Nixon precedent? I thought some of this stuff was settled with the delivery of the tape. When Nixon tried to deny and hold out, I thought that when they had to deliver that tape, which really sunk Nixon, I thought that precedentially this matter was settled, that the executive branch does have to turn over documents as requested by Congress, a co-equal branch.
Well, in the Nixon case, when he had to hand over the tapes, that wasn't to Congress. There was a criminal case. They were not pursuing him, but they were pursuing someone else. They wanted the evidence. They'd subpoenaed it. And so that was a court ordering as part of a criminal case that he had to turn over the tapes. Congress does have a subpoena power, and they could turn to the courts to enforce it. But if the president resists, or any of his people resist, again, the remedy for that is impeachment. So basically what they're saying is, we don't think that you have the votes to do anything about it. And if they're right that they don't have the votes to do anything about the Ukraine situation, they risk losing some of those Republican votes that are sticking with the president if he's stonewalling. So they might say, look, I don't think that there's anything with this Ukraine stuff, but I do think that you need to produce evidence when Congress supports it. So you lose me there. So maybe I won't support Article 1 about Ukraine, but I'll support Article 2 about...
So let's talk about two tracks, though. Let's talk about impeachment versus going the route of the courts to enforce the subpoena. So, like you say, the remedy to not getting the information is impeachment. But if we're trying to get the information in order to prove the need to impeach, it's a circular argument. So I assume that the House will approach this on two tracks: continuing the impeachment inquiry, continuing subpoenaing witnesses and collecting information and evidence from witnesses, while at the same time, I assume they're going to be going to the court. So I'm asking you now, of course, again, as a law professor who studied these things in terms of precedent, if this works its way up to the federal court, including to the Supreme Court, the issue of whether the president has to hand over this or that information that could be damning, that would add to the impeachment process. Now I'm asking you a guess question. What do you think, based on your scholarly research and knowledge, what do you think the federal courts, including this Supreme Court, would say to a challenge where basically Trump is, as you said, stonewalling, not providing information, that Congress is saying, hey, we need this information in order to evaluate whether to impeach?
Well, one thing I've learned after decades of following the Supreme Court is not to try and predict what the Supreme Court is going to do. I can speculate, but there's a legal doctrine called the political question doctrine. If the question is just, is this legitimate, does he need to respond, the answer is yes. The court would say yes. But there is another possibility, which is the political question doctrine, which is anytime the Constitution says this isn't for the courts to decide, it's for someone else to decide, the courts will say, we're not going to get involved. We're not going to say what he did was okay, but we're just not going to get involved at all. So what they would say is, yes, he does have to comply with this, but we're not going to issue a court order for that because Congress enforces this with their own impeachment power. So the courts would say, if you have a problem with this, Congress, you need to take care of it yourself. And
even in a case where
maybe they might say that.
But it seems so. In a case where you have a classic kind of a showdown on the issue of like co-equal branch of government, on the issue of executive authority, where the president is asserting executive authority, which I understand President Clinton did now and again as well. Mm-hmm. Various presidents, both parties, have asserted executive authority, executive prerogative to keep certain things secret. I mean, if ever the Supreme Court, you'd think, would be called on to actually settle something, it would be when you have a big blowout fight, a big throwdown between a president and Congress.
But that's precisely when, under the political question doctrine, they won't. They'll say, work it out, your kids are fighting, just work it out between yourselves. That's when they say it. If they say we're not getting involved, they'll say it's because of the political question doctrine. If they want to get involved, they'll say, well, not so much of a problem. I think it's also important.
So they could dodge it.
They could. Well,
And what would you say? Is it 50-50? If the question was, the president won't hand over this info. We need this info to determine an impeachment. The president won't give it to us. Supreme Court order him to give it to us.
Yeah, I have no idea what they would do. There's never been a case like it. So
50-50, would you say odds?
I would say more likely than not that they would say it's a political question, but I don't know.
They would.
Here's an important little angle on this, though. Ordinarily, in a criminal case, you can't be forced to testify against yourself. So if they're trying to get evidence from you and you don't want to provide evidence, you can
Take the fifth.
Take the fifth. You don't have to provide it.
But in this case, it's not a criminal
It's not a
penalty.
criminal
The only
penalty.
thing at stake is your office.
So, in a criminal case, they can't say, well, you didn't testify. I'm going to infer from the fact that you don't want to testify that you're guilty, that you're hiding something. You can't do that.
But you
in an
can in
impeachment
this
case,
process.
absolutely. They can say, look, we've got some evidence. You have a chance to disprove it. If you're not going to testify, if you're not going to provide the documents, we're going to assume the worst. And they can do that. There's nothing stopping them from doing
you've made a very good point about that, and that's something people need to remember, because I keep hearing the Republicans say these different things like this is a criminal case. I keep hearing them say, well, the president, he should have a chance to call witnesses and blah, blah, blah. This is the prosecution phase, okay? This is the indictment phase. This is the investigation phase. The trial's in the Senate.
Right.
So hold off. Spare me, these people.
Yeah, that's a fair point.
And so, and I want to ask you this. I said this in the intro. Definitions matter. Okay, I'm sorry if we're going overtime, but these things we got to get to the bottom of it. High crimes and misdemeanors. What does this mean? Now, come on, you're a law professor. For God's sakes, I want some answers here. So the House is trying to put this together. They're going to have articles of impeachment. And I understand it's not exactly a legal process; it's a political process because we're trying to determine should he stay in office or not. But he can only be impeached if he's found guilty of high crimes and misdemeanors, right? So how are high crimes and misdemeanors different from low, regular crimes and misdemeanors, or are they?
So the first thing that's important to get out there is, despite the name high crimes or misdemeanors, they don't have to be crimes. In fact, even when they are crimes, when they impeach people for them, judges or presidents, they don't say he committed this violation of the criminal code. They will say what he did. He accepted a bribe or something like that. But the point is, the high crime, high means public, like high treason. High crime means it's an offense against the public, so public misconduct. So if the president robs a liquor store, even if he murders a couple of people, that's not a high crime as high crime means. Now, a murder, they might make an exception, right? They're going to say, okay, it has to be public or it has to be really bad.
So Trump can't just shoot somebody on Madison Avenue.
Well,
like he said.
It would probably have some people saying, well, technically this isn't a public offense, but realistically I think we can assume, and most people who write books about these things, about what high crimes and misdemeanors mean, will concede the point that even though it means public misconduct, you'd throw in serious private
So
crime
look,
too.
this is revolutionary, what he just said, okay, for average Joes like myself. For us non-lawyers, what he just said is absolutely crucial. That high crime and misdemeanor is doing a crime in a public way. And so that...
It doesn't have to be a crime.
It doesn't have to be a crime.
Misdemeanor, when they wrote that, misdemeanor didn't mean what we take it to mean, like a minor crime. It meant...
an offense.
Right, like forgive us our trespasses. Well, it doesn't mean technically the legal definition of
public
trespass.
a public offense. This is revolutionary to the average person, to me, because yes, we've heard that so many times, and yet we don't know what it means. And so when the president calls out, "Hey Russia, if you're listening," "Hey China, do this to the Bidens," that could be a high crime.
Absolutely. Well, there are two things to think about here. One is we know it every time there's an impeachment case, the defense will say it has to be a crime, and the people in favor of impeachment will say no, it doesn't, and they'll cite all the precedents, centuries of Anglo-American practice.
Lindsey Graham, they've got him taped on the floor of the Senate during the Clinton impeachment, saying it doesn't have to be a crime.
And he was right. And now, if it is a crime, that certainly means something. But there are all these presidential powers. What if the president abuses his pardon power? What if the president negotiates a perfidious treaty where he's betraying the country? What if there's an emoluments clause violation? None of these things are crimes. But all of them are things that when they were framing the Constitution, when they were debating the Constitution, they said the remedy, if the president abuses this power, is impeachment, even
So
though
it's
they're
really,
not crimes.
so this is why Nancy Pelosi keeps talking about abuse of power, presidential abuse of power, because it does not have to be a crime as we regularly define it.
Right. And
It is
Nixon,
an offense. Would it be fair to say it's an offense against the republic, an offense
against the
the
public
nation?
trust, absolutely. And in Nixon's case, the things that he did were crimes, but the articles of impeachment charge him with violating his oath and violating his constitutional duty to take care that the laws be faithfully executed. So they make that distinction. Now, what that means is the bar for being a high crime or misdemeanor is pretty low. If it means public misconduct, you can make a case for pretty much every president having done something that clears that bar. So here's what's a high crime or misdemeanor. Then here's what the House is actually going to be willing to impeach about. And people talk about, Gerald Ford famously or infamously said, an impeachable offense is whatever a majority of the House says it is. And I flip that around. Because so many things are high crimes or misdemeanors, and so few people are actually impeached, I say a high crime or misdemeanor is only what a majority of the House is willing to say it is. And a removable offense is only what 2/3 of the Senate is willing to say is one. And that's not much. That's where the bar is set high.
So you would agree with President Ford on the issue that there is not a great deal of clarity about what constitutes an impeachable offense.
Well, we're supposed to try and look at what the phrase means and what it meant when they wrote it and how
But
it's been
there's
used
not a lot
since
of
then.
precedent.
We have a lot of precedent. Usually it means public misconduct. The other thing is the Constitution doesn't say high crimes or misdemeanors. It says treason, bribery, or other high crimes or misdemeanors. So when they say or other high crimes or misdemeanors, what they're saying is it means things like treason, like bribery. Well, what are treason and bribery? Those are offenses against the public trust. You're a public official, you're not supposed to betray the country. You're a public official, you're not supposed to take bribes or give bribes.
That's really very helpful. All right, so if the president is impeached by the House, if there is that vote, you've clarified that there doesn't have to be a vote to kick it off, but there does have to be a vote on whether or not to impeach at
Right.
the end, if it's going to move on to the Senate. So presuming that vote happens eventually after all of this investigation and subpoena and testimony, presuming that the House goes ahead and votes to impeach, then what?
So it goes to the Senate for a trial, and they have rules for how to conduct the trial, and they could change those, but they've pretty much stuck with the same rules for a good while now.
The Supreme Court, the Chief Justice.
If the president is the one being impeached, then usually the vice president presides over the Senate. But because he has a conflict of interest here, if the president is being tried by the Senate, then the Chief Justice of the United States presides over the trial.
Presides over the Senate, in essence,
Yes.
during the trial.
So they basically don't do anything else if it's the president. Now they can. Sometimes if it's a judge and it's not a big deal, they'll just have a committee gather all the evidence and then they'll present it to the full Senate. But for a president, they would have the full Senate conduct the trial. Most of the rules are set out in a fair amount of detail. One thing that's not is admissibility of evidence. You're in a criminal case, you have the federal rules of evidence, everyone knows what the rules are. This is a little more loosey-goosey, and so the Chief Justice would have some discretion over what to admit into evidence, what witnesses to compel or not, who's relevant, who's not. When Clinton was put on trial in the Senate, Chief Justice Rehnquist took a pretty hands-off approach. He made rulings when he had to make rulings, but anything that the Chief Justice decides is subject to being overruled by a majority of the Senate. So 51 senators. So
in essence, the Senate majority,
Yeah.
Mitch McConnell, in essence, will have veto power over the process.
yes, and the rules don't allow things to be completely shut down that easily, and I think we would have a trial. But if there's a majority of 51 senators that were hanging together on severely restricting what evidence was admitted, things like that, then they would have their way. That is true.
All right, so then the Senate votes, and the Senate either votes to convict or not. In President Clinton's case, they voted not to convict. And if they vote to convict, then what?
If they vote to convict, the moment that that vote is final, the president is not president anymore. The vice president becomes president, not just acting president, becomes president.
So Vice President Pence would immediately, after the conclusion of the vote in the Senate, would assume the presidency.
Yes, and for those saying, well, then what if he's impeached and removed, then we'd have President Pelosi. When there's a vacancy in the vice presidency, when the vice president becomes president, for instance, then 25th Amendment Section 2 allows the vice president who's become president to nominate a new vice president. Majority of the House, majority of the Senate confirm that person becomes vice president. And even if there were enough Republican votes to impeach and remove Trump and Pence, there's no way that they would remove both of them without confirming a new Republican vice president in between. So no President Pelosi.
So now again, my final what if. So then if he is convicted, we touched on this a little bit before, if Trump were to be convicted, I just have to ask because we have a very unconventional person in the office. I mean, part of how he got there was by being unconventional. Could he run for re-election?
He could try. There is nothing in the Constitution that says automatically, if you're impeached and convicted, that you can't do anything. Again, it just removes you from that office you were in. But if the Senate, by a simple majority, after conviction, by 2/3, by a simple majority says, we're disqualifying you from future office, and if he decides to test that, and maybe the courts would rule on it, their qualifications for running for president, they would say, well, that doesn't apply to elected office. So, yeah, he could try. He could try to run again. Even if they disqualify him, he could say, doesn't apply to the presidency. Very unlikely that he would have the support. If he didn't have enough support to avoid conviction, that he would have enough support. But no, third party run, all sorts of crazy stuff could happen.
So as we wrap this up, Professor Kalt, is there any way, I like to get you to predict things. I like to give answers to our viewers, and I want answers. Any way to predict how much time that the Senate might take, how much time the House might take wrapping this up? Here we are, end of October 2019. Any predictions on how long the impeachment process might take to wrap up in the House? Let's start with that.
Yeah, I try not to make predictions, especially about the future, but I would predict, based on what I've heard, and that and $2 will get you a cup of coffee, but what I've heard is the committees, the House committees, are going to try to get something done before Thanksgiving. Then it goes to the full House. They're going to debate that. They would probably have an impeachment vote then sometime in December. The Senate.
So it would be like a Christmas gift.
Well, if the Senate has to have a trial, they would probably want to wait till after Christmas. So the trial would be after. But here's the thing: impeachment sucks all the oxygen out of the room. You can't do anything else. You can't get any legislating done. You can't get any campaigning done. And we're coming up into an election year. So what I would expect is, whatever happens, the one thing both sides could agree on is that they want to get it done.
Let's be expeditious about it. Let's be as quick.
Absolutely. And the rules for the trial in the Senate make it hard to really delay things too much. For instance, we talked about how the Senate can overrule the Chief Justice. Let's argue for 4 days about whether this witness should testify or not. Well, if they overrule, it's by a simple majority vote with no debate. Unlike the filibuster prone everything else, no debate. So, yeah, there'd be a lot of back and forth, but I would expect them to try and do it expeditiously because none of them want to be prevented from doing everything else. So to push you a little bit,
Professor Kalt and I are predicting that all of this impeachment, conviction, all of this stuff is going to be wrapped up by end of February, mid-March.
Yes.
Can I say that?
I would say end of January, mid-February.
Really? Okay.
However, one caveat is you never know what else comes out. So if they're talking about Ukraine and then something else happens,
that could.
Impeachment isn't one bite at the apple. They can impeach and then something else comes up. At a certain point, they'd say, well, let's just wait till the election and let that sort it all out.
So the House impeachment process could continue to drag out as new evidence comes in, because they would be adding to the articles of impeachment, right? They haven't right now settled on the articles of impeachment. That's what the vote would be on.
Right. So if I would expect to keep things quick, while they could say, well, we've got Ukraine, we've got the Mueller report, we've got the emoluments clause, I would expect them to keep it simple and go with their strongest case, the thing that they think they have the most votes for, go with that. And if that doesn't work, they've got the other stuff in reserve. But if the strongest one doesn't work, then those other ones won't, unless some new evidence comes in. But you never know. New evidence comes in, and you're back to the impeachment inquiry and impeachment vote and maybe another trial.
Well,
stranger things have happened.
Professor Kalt, I really appreciate this. He is the author of Constitutional Cliffhangers, and we could have a cliffhanger. So I'm not going to swear that I won't bother you again, because this is a very important subject. It's a very serious subject, not one that I approach, or I think anybody does, with glee. Something that I think Americans need to gird, the old gird your loins. I think Americans need to gird themselves for. I think that we need to clad ourselves in information. And we're going to talk again about political dialogue in this country and political discourse. But look, this is an issue for all Americans. And so let's start. And I love your dispassionate approach. And I don't know, by the way, I didn't come into this interview knowing if Dr. Kalt is a Democrat, Republican. It doesn't matter. I knew that he was a dispassionate expert. And that's what we need. We have to start with the facts. We have to start with what is the law. We can have our opinions. We're entitled to our opinions. But especially in a matter like this, let's all of us, Democrat, Republican, Independent, get the facts. Let's understand the law. It's our system. The beauty of this country is it belongs to all of us. The Constitution belongs to all of us. So let's try to wrap our heads around it. I'm not a law professor, never will be, but we're going to continue to bother folks like Professor Kalt here. Really appreciate that you're willing to share with us. We're going to try to get the word out. And again, always starting and ending with the law and the facts and the precedent, and then see where it takes us.
Absolutely.